Welcome, everyone. It's really terrific to finish up our set of 3 Easterbrook Week panels. I know some of you have been with us for all 3 panels, and I've certainly enjoyed the previous 2, and I'm really looking forward to this one, as is Frank, I think. So before we get going, I want to thank the University of Chicago Law Review again, which has done some really terrific work on editing the essays that you'll hear the authors present. In addition to the papers that you've heard presented during Easterbrook Week, there's a number of really terrific articles that members of the faculty have written. Richard Epstein has a great paper about the Second Amendment. Tom Ginsberg has a really fun arbitration paper. Julie Rowan has a really interesting paper on employee benefits. Todd Henderson, a really neat paper on a Jones case. A fun article on mail fraud, and I have a really second-rate article about pseudonymity in litigation and when people should be able to sue as John Does. The Law Review issue will be coming out later this year. I'd certainly encourage those of you who've enjoyed the panels here to read the papers in their physical form and to read some of those other papers that weren't presented. I was tempted to do a panel, sort of we'll call it a Law of the Horse panel, for those papers that didn't fit as well. They were very good, but didn't fit as well in the subject matters for the other 3 panels, but I think that would have been extremely disrespectful to our honoree, who has expressed in writing deep reservation about sort of the grab bag approach to legal education, where you try and put together a mishmash of concepts. His article on the Law of the Horse basically suggested that there was no such thing as cyber law, and has given cyber law scholars really severe inferiority complexes for the last couple of decades since he wrote it. Okay, so because we've got 4 terrific papers, we'll really do our best to limit each presentation to no more than 10 minutes. Without further ado, I'd like to ask Douglas Baird to talk through his paper on Frank on bankruptcy. Then Martha Nussbaum will talk about a case that involves statutory interpretation and constitutional law and freedom of religion. Then Saul Levmore and David Strauss will present their papers about Frank's general statutory interpretation methodology and some of the more interesting theoretical issues that arise therein. Okay, Douglas, thanks.
Great. Part of this project, I read every single one of Judge Easterbrook's bankruptcy opinions, and I had a couple of reactions. First, my 2 prize winners for best opening lines. One of which, I won't tell you how the case came out, but you can guess. The opening line is, "This case presents a conflict between a statute and its legislative history." Turns out the statute wins. Then the other one, which I think is more salient for what I'm about to say about his bankruptcy jurisprudence, begins, "This case of first and last impression presents the case of whether," and then goes on to describe the issue. There are a lot of his, as surprising as it seems, some of his bankruptcy opinions are not that interesting. On the other hand, I sort of thought to myself, if I were an archaeologist 2,000 years from now and I wanted a sense of what bankruptcy law was like at the turn of the 20th century, actually you could actually extract from these 60 to 70 some opinions, actually a pretty good view of what bankruptcy law was like. It cuts across a vast range of issues. And my other embarrassment in reading the cases is that basically got everything right. I'm sort of trying to grade him and say, no, I mean, he really understands the stuff. His understanding of bankruptcy law is really pretty close to mine. Now, unfortunately, causation there I think goes actually 2 ways. And since I've known the judge for almost 30 years now, actually more than 30 years, I think a lot of what I think about bankruptcy is what he thinks, which is why so many of his opinions strike me as being correct. The particular opinion I talked about is a case called Kmart. And what happened in Kmart is on the first day of the case, the lawyers, without any preparation or any justification, walk in front of this hapless bankruptcy judge and says, "We'd like to spend $300 million because we feel like it. We think these people should get paid right away. And it's just not part of our business plan to do anywhere else. It's really much more convenient and easier for us if we do that. So we're going to pay these creditors 100 cents on the dollar. $300 million is going to leave on the first day of the case, and that's just because it's part of our business plan. This is appealed to Frank Easterbrook and asked, is this okay? And his attitudes, are you kidding? Of course not. You can't do this. You can't have no record, no explanation, and give some creditors 100 cents on the dollar while a bunch of other people are basically getting next to nothing. This is crazy. There's nothing in the bankruptcy code that authorizes it. And then he goes to the issue of saying, well, can you ever justify a payment like this? Well, maybe you can. There's a provision of the bankruptcy code that says you can use assets of the estate outside the ordinary course of business if you get the judge's approval. But this doesn't mean you can just give away money. You have to have some justification. You have to do something to show that it's actually going to make people as a whole better off, that it's somehow in their interest. And this is a case. And then he goes through a long laundry list of things the judge might have done, or the things parties might have shown that would have remotely come close to somehow saying this was actually a sensible thing to do. And he said, they could have done this, 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 they could have done this. They didn't do any of these things. So these guys, of course they can't win. End of case. Okay, now, what's the upshot of all this? First, let me give you the one piece of happy news and then the two pieces of bad news associated with this opinion. First of all, this practice of approving these motions on the first day had gotten completely out of hand. And bankruptcy judges and lawyers were saying to me privately, this is crazy. This is no way to run a system. And unfortunately, we've gotten into this mode where no judge is afraid to turn these people down. No lawyer is afraid of not asking for all these things. And we wish somebody would come in and stop this nonsense because it's ridiculous. And then Easterbrook hands down this opinion, and all of a sudden the practice changes. Not simply in the Seventh Circuit where his opinion is binding, but everywhere else where people basically said, look, you can't do this without making some kind of record. If the judge approves these kinds of things, it has to be modest and temporary if possible. It has to be tempered. It has to be considered. It has to be reasonable. And so essentially the decision that he handed down in Kmart is now universal. And it's absolutely accepted everywhere, and this one decision completely changed bankruptcy practice. Okay, so the question to be asked is, in return for this, if you're a federal judge, what do you get? Do you get a parade down Wall Street? Do bankruptcy judges come up and give you high fives? Do bankruptcy lawyers come and say, job well done? Okay, one thing they did do is they'd come to me and say, Frank got it right. Thank God. What a relief. Okay. What happened publicly, however, is they hated him, and for two different reasons. The primary one of which, though, is that they completely misread the opinion. They took everything that Easterbrook said the bankruptcy judge did not do but could have done, and say, what Easterbrook has imposed upon us is a 12-factor test, and you have to satisfy this 12-factor test. And so the first thing they do is, while what he said is followed everywhere, the way they interpret his opinion is nonsense. It isn't what he says in his opinion, but it's how his opinion is interpreted. So if you go to a cocktail party, you talk to a bunch of bankruptcy judges, ask them about this case, they will say, first, something that has no connection with what he actually said. And secondly, because they think that that's what he said, nobody has filed a large case in the Seventh Circuit since he handed down this opinion, which means if you're a bankruptcy lawyer in Chicago now, you're broke, even in these times. So basically, he single-handedly restored sanity to bankruptcy practice and destroyed bankruptcy practice in the Northern District of Illinois at the same time. So that's the interesting story of this case. The interesting story of the case is that it's a completely sensible, correct decision that's been universally adopted, universally criticized, and universally misunderstood. At any rate, my basic bottom line on this is, Frank, job well done.
Terrific. And now it's Martha Nussbaum's turn.
Okay. Well, my case is Block versus Frischholz, which is often known as the mezuzah case. It's a case that's of interest for a number of reasons. It raises important issues about the interpretation of the Fair Housing Act and partly overrules Halpern, the circuit precedent. It raises questions about how to distinguish intentional religious discrimination from a neutral rule that incidentally burdens religion. But my primary interest in the case is the judicial process that's involved in it. And I focus on the cooperative inquiry that goes on in the oral argument, but no doubt in other parts of the court that we can't study so easily. And I say that, look, there's this conventional wisdom that judges are always fixed and they vote based on their ideological preferences. And no doubt that's sometimes true, but what we actually see in Block is what I call the Chicago School of Judging. That is, surprise, surprise, people who are trying to get things right, who are really listening to each other, arguing together, thinking about the status of hypotheticals for a disputed distinction, and in general exhibiting a kind of reason-guided flexibility, which I think you can see in other decisions of Judge Easterbrook's as well. So the facts of the case are fun. In 2001, the Shoreline Condo Association in northern Chicago passed a new rule to eliminate clutter in the hallways. And it basically said that objects could not be placed in the hallways. For 3 years, this was not understood to apply to the mezuzah that an observant Jewish family, the Blocks, placed on their door, which is a very small rectangular box with a Torah scroll inside, which observant Jews are required to put on their exterior doorposts. So that just wasn't the kind of clutter that the rule was applied to. But in 2004, there was a new head of the Condo Association who didn't particularly like the Blocks, and all of a sudden the mezuzah was taken down. So there was a kind of a new rule, which was a reinterpretation of the old rule. And they were so vicious about it that they even took the mezuzah down during the funeral of the Block's father, when the rabbi had actually come to the condo to conduct the shiva. So it was a very ugly dispute, and the Blocks filed a lawsuit seeking an injunction against the Condo Association and also damages for distress and humiliation. Their claim for an injunction was mooted by the fact that the city passed a law making it illegal to do what the Condo Association was doing. But then their claim for damages remained alive, and the district court, looking at the facts, granted summary judgment for the Condo Association. So then the Blocks appealed, and a 3-judge panel, including Judge Easterbrook, affirmed. Judge Easterbrook, joined by Judge Bauer, agreed with the district court that Halpern precludes claims, this circuit precedent, Halpern precludes claims for post-sale conduct under the Fair Housing Act, unless the conduct is so severe as to amount to a constructive eviction. And then, addressing the issue of intentional discrimination, which was relevant to another section of the Fair Housing Act, Easterbrook argued that the hallway rules were simply neutral rules, and that what the Blocks were asking was for an accommodation. But the Fair Housing Act doesn't require accommodation for religion, only for disability. Well, Judge Wood dissented, and she argued that there are a number of theories under which a rational trier of fact could find in favor of the Blocks. So the issue here is whether they can avoid summary judgment. And she said, first of all, there is plenty of evidence on the record to support the claim of intentional discrimination, certainly enough to avoid summary judgment. She also argued that a strong case could be made for seeing the condo policy as tantamount to a constructive eviction, because observant Jews just won't be able to live there under those rules. And she was trying to squeeze it in, as it were, without overruling Halpern, since that wasn't an issue at this point. But she argued that somehow or other this could be consistent with the narrow theory articulated in that case. Now, just to go rapidly over the Wood opinion, her opinion attracted a lot of attention, people discussed it a lot, and then the court agreed to rehear the case en banc. and in November of this year decided unanimously in favor of the blocks. So in other words, Judge Easterbrook had changed his mind, and changed his mind on, it appeared, not on Halpern, because of course then the court had decided to overrule Halpern, which they could do en banc and not in the panel, but on the facts. As it turns out, he does change his mind and votes with they all vote together, and there's only a single opinion, and the single opinion written by Judge Tinder states that Judge Wood is right about the facts, that the factual record shows enough evidence of intentional discrimination to give rise to a case that can go to trial. Now, the court's opinion does not accept every part of Judge Wood's theory of the law, and I think what's very nice about the case is that everyone listens and gives up something. So Judge Wood gives up the claim of constructive eviction. Judge Posner, who wrote the majority opinion in Halpern, gives up Halpern as he had previously interpreted, and Judge Easterbrook changes his view about the facts. So basically what happens at the oral argument, I argue, is crucial to the resolution of the case. And if we look closely at the oral argument, we can actually see some interesting things happening on both the facts and the question of whether the Fair Housing Act can be interpreted to apply to post-sale conduct. So let me just take one little chunk of that, because I think it's a nice example of good judicial argument. So the attorney who represents the blocks, Gary Feinerman of Sidley Austin, argues that the Fair Housing Act, in referring to conditions and privileges of sale, includes some post-sale conduct. He says, well, look, when a person buys a condo, part of the terms of sale involve being bound by the rules of the condo association. The contract of sale creates an ongoing relationship with the association in such a way that the rules of the association are legitimately seen as part of the terms of sale. And then an attorney from the Department of Justice Civil Rights Division came forward and agreed with that, saying, look, HUD has interpreted it that way, and under Chevron is owed some deference. Well, now then comes the lawyer for the condo association, and I think there's kind of high comedy, or maybe even low comedy in this, because he was not well prepared for the barrage of questions that he encountered. So Judge Easterbrook helpfully offers him two options. He can argue that condo association rules are not conditions or privileges, or on the other hand, he could argue they are conditions, but conditions of occupancy, not conditions of sale. Well, initially, this guy doesn't understand that distinction. He gets it utterly confused, and Easterbrook points out to him that he's confused the two, and so eventually he opts for the second. Now, then, Easterbrook presses him on Chevron. He says, well, look, if HUD sees it the other way, interpreting condo rules as falling under conditions of sale, do they have the right to say that? And Hartwell, he says, no, they have no right. They just re-legislated the boundaries of the Fair Housing Act too. And then Judge Easterbrook cuts him off and says, that's just a kind of op-ed page rhetoric. I mean, nicely rejecting the ideological posturing that this guy was engaging in. And he then presses on. Are these rules related enough to the sale to count as conditions of sale? So he says, is there any doubt in your mind that anybody who buys a condo takes it subject to the condo association rules? Now, at this point, Judge Wood steps in and says, well, the condo association rules condition the package of rights you've just bought. And the lawyer objects. He says, I would like to answer Judge Easterbrook, please. I haven't finished answering him. And then both Judge Easterbrook and Judge Wood, talking almost at the same time, say, look, we're asking exactly the same question. And so then they press on and ask a few more questions in this vein. Judge Wood says, if a condo association passes a rule that says there will be no African American visitors, will that violate the Fair Housing Act? Hartwell says, no, that affects only the visitor and not the seller. And Judge Wood says, oh no, it affects both people. Now Posner comes in at this point, and he says, asks about Chevron, and once again Hartwell backs up into his ideological position about Chevron and says HUD doesn't have the authority to outstep the boundaries of congressional intent. And Easterbrook now becomes rather impatient and says, we're not interested in what you think, we're interested in what the statute says. So then they go on, and Posner asks, what if the condo association says, we'll sell to Jews because we have to, but we'll make it uncomfortable for you to live here because you're going to have to wear a yellow star? Is that lawful? And then Judge Sykes, actually the only other one who speaks during the whole oral argument, except for a couple of words, she steps in and she says, suppose the condo association says the trash collection of Jewish owners will be suspended. Well, Hartwell says it would be discriminatory, but is it actionable, says Judge Wood. Well, not under the Fair Housing Act, says Hartwell. And this time Posner takes over. He says, certainly that would be goofy, wouldn't it? He says, suppose the landlord says, I'll sell to Jews, but you do have to wear a yellow star. Well, then Posner, Wood, and Easterbrook all laugh together. And then this laughter spreads and apparently encompasses the entire courtroom. And I think it's a nice moment because the laughter creates a kind of community of argument in which the ones who understand what's going on are on the inside, and poor Hartwell, to whom these people are no doubt paying a high special assessment for his services, is left on the outside. Well, so what has happened here is that they're reaching a consensus that it's unreasonable or goofy if conditions and privileges doesn't extend to the rules of the condo association that pervasively condition your life as an owner. Well, that's what leads in the end to their partial overruling of Halprin. So a conclusion of great legal importance is reached through careful consideration of hypotheticals and of Chevron deference. And I think it's a nice example of a kind of cooperative inquiry. Well, the other, just to wrap up, the other major issue is dealt with in a similar way, which is the issue of the factual record on intentional discrimination. That's very closely linked to the statutory issue because, as it turns out, as they interpret the statute, it will allow the blocks to seek relief only if they can show that there's enough evidence of intentional discrimination. And the key issue then is, are they just asking for an accommodation, or is there enough evidence that the discrimination is intentional? And on this issue, they reach a consensus again that Judge Wood's initial view of the facts is the right one. So my conclusion is one that's not so surprising, but at least somewhat surprising in the current day, which is that judges under Judge Easterbrook's leadership of the court, the judges are reasonable, and they try very hard to get things right.
Thank you, Martha. Saul, it's your turn to instruct us on the jurisprudence of Judge Easterbrook.
Thanks, Leo. So let's talk about statutes. Here are a few things you need to know, either if you want to summarize Judge Easterbrook's view of statutes, or if you're a student, or if you're appointed to the bench tomorrow and you want a short lesson. Easterbrook tells us that legislative bargains should be upheld, no matter how unpleasant they are. If interest groups got their way or something, uphold the bargain, make the legislature see the result. Second thing is, where there's some yawning gaps out there in the statutes they passed, it's not the judge's job to fill the gaps. I'll just say as an aside here, because we won't have time for it today, you notice that that's not necessarily the same view that you might have if it was a contract you were filling, or even the Constitution you might fill in, because in one case it's hard for the parties to go back and do it again. Congress can redraft the statute, the framers are long gone, though it's not exactly the same Congress, I recognize. And in private contracts there might be other considerations. So I'm just talking about statutes here. And then finally, third, though there's more to be said, when the statute is not applicable, do either nothing or as little as possible. Don't step in and judge where the statute's not there. And my paper focuses on opinions in which the statute is not big enough for Judge Easterbrook or others to call it a gap, but there is a kind of ambiguity. The words have uncertain meanings, the applicability is uncertain. Now, for Judge Easterbrook, as well as I think for anybody in this law school who takes a course in public choice, or maybe in elements or in other things, as the famous article by Ken Shepsley says, Congress is a they, not an it. By which we mean Congress, the legislature is a group. The group has passed the statute. Imagine the statute passed 60 to 40 in the Senate, even if we just think about one chamber. It just gets more complicated with more than that. But you have 60 voters voting for something. Even if we're sure we could divine the intent of each of those 60 persons, what does it mean to say we want to know the intent of the group that voted for it? And the modern public choice, and certainly Easterbrookian way of looking at it is, there's really very little we can say, because 60 people might have 3, 10, even 60 different things in mind, different sets of preferences about why they voted for a given statute. So to ask what they thought the function of the statute was, or what they were trying to accomplish, or how they were trying to resolve a trade-off, you can't really look in their mind. Even if you have legislative history right on point, you might have one person's legislative history. That doesn't really have much going for it. So to take the easy case, but I think the most important case, the judge is not interested in arguments, the sort of arguments that you hear in moot court, though hardly moot court in this building, but the arguments that you hear in moot court elsewhere, where somebody would say, well, the case would be, should there be a private right of action in this statute? It didn't say anything about whether an individual can sue. And, one litigant, it's just predictable. Litigant stands up and says, well, the purpose of the statute is to end discrimination. Congress wanted less discrimination, not more. We'll get less discrimination if you give my client a private right of action. QED, this should be a private right of action. Easterbrook's reaction to this is, thundering disgust. Don't be stupid. Everything's a trade-off. More isn't the way we do things. Everything has a cost. And Congress in the statute was setting the terms of the trade-off, less discrimination and more docket, or more time, or more of this, and more of that, and more uncertainty. And everything is a trade-off, and you need to look and see what the trade-off is that Congress went after. It doesn't do any good to have each side say that there is a purpose that they can somehow divine. I'm completely in sympathy with that, as those of you who have taken a course with me know, but of course it's not fun just to agree. So let me point out a couple problems as I do in the paper. So one problem, and I'll return to this at the end of my remarks as well, one problem is that, the thing doesn't work so well when you're the only judge that does this, or when there are a few judges that do it, but other judges just don't get it or don't follow suit. The idea, after all, is to tell Congress it's your job to draft statutes and to do it carefully. I'm not going to make believe I can see your intent when your intent is a kind of incoherent thing. The idea of holding parties to their bargains is for Congress to see, don't punt to the courts to get them to control interest groups. You got to come up with the bargain yourself. The problem with that is that if other judges are going about things differently, other judges are making believe they can see intent or believing they can, other judges are not enforcing the bargains as they are, but kind of holding their nose at some and pouncing on others and being what they think of as public regarding as judges, then the feedback loop is broken because the legislators, even if they read these opinions, will go ahead and pass statutes just as they did before and say, well, it might be our bad luck if we get that guy Easterbrook in the Seventh Circuit, but there are plenty of other judges around that we can punt to. Let's just hope we get the right receiver over there. And, maybe it's time after 25 years of getting it right, so to speak, for us to wonder, certainly for academics to wonder, what's the system going to look like if you have a few judges doing this coherent thing and most judges doing this seemingly incoherent thing, but the very thing that generates this activity in Congress. Now, I'll return to that in a moment. But moreover, there's an intermediate ground where I think maybe there is just a little bit to be said for intent. And the intermediate ground goes like this. It's certainly true that when we have a group, we can't say that we know the intent of the group. Maybe there is no intent of the group. Again, even if we vote for 70 pounds of chocolate ice cream, the way you like ice cream and I like ice cream and she likes ice cream might be completely different. We don't have any idea why you vote. I might vote for it because I think the ice cream manufacturers need some support. You might vote for it because you don't like other taxes and so forth. Nevertheless, there might be some cases where we think we can divine that an overwhelming majority of the legislators really did have the same intent, function, purpose, whatever. Well, let me try 2 examples on you, drawn from Easterbrook opinions that I talk about in this paper, though not the one I spend the most time at, because that would take the most time to unfold here. Imagine you have a statute that says something about the company can do something if substantially all the assets are sold. It's intentionally ambiguous, you might say. Why couldn't Congress just give us a percentage of the assets? Why'd they have to say substantially all? Wouldn't it be convenient if every time you looked at substantially all? By the way, Easterbrook is perfectly willing to look at legislative history to see what the words meant when the enacting Congress enacted it. So if we find out that when the statute was passed, everybody knew that red meant a certain color or a certain piece on the spectrum, then that's what red means. And similarly, if everybody agrees that everybody knew at the time that substantially all meant 81%, then substantially all means 81%. But what if not? What if it sometimes means one thing and sometimes another, and it's all over the map? Again, it's difficult. On the other hand, if you could say, looking at many, many statutes, overwhelmingly, substantially all means 80%, though sometimes it means 50, sometimes 70, sometimes 90, but then maybe it's not so terrible, I would say on behalf of the judge, though I criticize it a little bit in the article, maybe it's not so terrible to hold our noses a little bit and say, well, it's as if we can divine the intent. After all, sometimes everybody in a room votes for something, and they really do have the same thing in mind, and we could try to imagine that this is one of those kinds. Another one of his examples is the bankruptcy statute, so now we know that Professor Baird has read it. And, imagine that the debtor is protected, gets some protection against secured creditors, and is allowed to hang on to a mower. And the statute's passed in the 1930s. I'm changing the case just a little bit to make it go quicker. What does a mower mean? Well, by year 2000, a mower might be some very complicated piece of equipment worth over $1 million that mows, but, plays popular music and is air conditioned and does lots and lots of other things. It's meaningless to ask what the Wisconsin legislature in 1935 would have said about a mower that's air conditioned and also builds houses 65 years later. But one could try to make some guess about what a majority of the legislature would be. Otherwise, all those old statutes are out the window because we don't, what was a mower then is not a mower now, and you have to throw everything out, and you create thousands and thousands of gaps. So, by the way, that case seems a little troubling to me. After all, it's likely that mowers were protected not just because many legislators thought this was what a debtor needed to run the farm, but maybe some debtors like protecting the manufacturers. A lot of mowers were made in Wisconsin in those days. Maybe others protected the retailers. Maybe some were out to protect the workers on the farm. There might have been a lot of it might be that the legislature of Wisconsin was a they, not an it. Nevertheless, a reasonable judge might think, well, I'm going to make believe that I know that Congress is an it, not a they over there because it will work just slightly better. Well, let me conclude and say the following about the future, looking back on these years. When we look at contemporary statutes, look at healthcare reform, look at other things that are passed today, this intellectually consistent position that Easterbrook has and that lots of academics, including me, subscribe to, it looks, to criticize ourselves, just a little bit precious, right? We're sort of imagining that, well, Congress has got many preferences out there, and they pass a statute, and there's this feedback loop, and the judge says, we'll uphold the bargain, and but we know that most of these legislators, indeed in the healthcare reform bill, every single one of these legislators, there's not a single one that claims to have read the bill they're signing. There's probably not even a legislative aide that's read the whole bill, but different aides have read different parts of it. So I just will hazard a guess about the future and say, I think in the future it's quite possible that people will look back on this era, they'll call it the era of Easterbrook, and they'll say, well, in that era, judges, along with some academics, some judges took this intellectually consistent position that Congress was a they, not an it. But, that was just too ridiculous for us. Not only was Congress a they, everybody's an a. The drafter was a they, the agencies are a they, the president is a they. There's no president there. There are hundreds and hundreds of staffers in the White House writing things and deciding to veto things and all that. This obsession they had back around the year 2000 with statutory language and legislative bargains, it was cute and intellectually consistent while it lasted. But now we, in 2050, look back on that, and this is what I think they'll say, and we think, let's give up. Someone's got to fill the gap. Someone's got to be the agent of the citizens. And, if we continue to attract very, very talented people to the federal bench, and not so talented people to the Congress, and even less talented people to the federal agencies, maybe we'll put our money behind the federal judges and like them to be our agent, and them to go interpret things. They'll look back and say, well, it's nice that some people thought it was intellectually consistent, other people like me puzzled over when these judges might have overstepped even their own terms of what they did, but perhaps feeling that in the end there was insufficient support even on the federal bench among other less enlightened judges to allow us to continue to support this view. Thanks.
Thank you, Saul. Now David Strauss will speak about Easterbrook the scholar and Easterbrook the judge interpretation.
Thanks, Leora. Yeah, my paper is on Judge Easterbrook's extrajudicial writings on statutory interpretation. One of the many impressive things about Judge Easterbrook's career is the way in which, even while being prolific on the bench, he has made contributions of the first order to the academic literature as well. There are plenty of people who can't do either of those things. And so what I thought I would do is, in the paper, is focus a little bit on his extrajudicial writings on interpretation. The paper itself is kind of a train wreck, which I think its principal function right now is to frustrate my law review editor. So let me just talk about one particular slice of Judge Easterbrook's approach to statutory interpretation. One particular issue. It's an issue he's addressed in some of his writings, and the question is whether Judge Easterbrook's textualism of the kind that Saul just talked about, and I'll describe also, whether that textualism is conservative, whether being a textualist means you're conservative. It's a proposition that Judge Easterbrook addressed, and he said, no, it does not mean that. It's an appropriate question to ask, I think, because, the sort of conventional wisdom, I guess, is that Judge Easterbrook is a conservative. Anyone who knows his work knows that's a totally sort of insufficient way to describe him. Some of his people who thought he were his ideological allies have gone before him and gotten their ears pinned back. And I think Frank's commitment throughout his career has been to being lawful. I think that's his commitment, not to anything else. So I think it's a question that is appropriately raised in the context of his work. Let me talk about textualism first, or at least Judge Easterbrook's version of textualism, which is more sophisticated than some others. I think there are two main principles that he avows. The first, which Saul talked about so well, is the text of a statute reflects a compromise. For most statutes, at least for most statutes that present difficult questions of interpretation. So what does that mean? Well, here's what it means. It means that if you approach a statute by saying, I'm going to interpret this statute in a way that promotes its purpose, you have betrayed what the statute really does, because a statute doesn't reflect a purpose, it reflects the result of conflicting purposes. And if you just say, well, here is a purpose, you are handing an undeserved victory to one of the contesting parties. I think that's sort of at the core of his textualism. The second part of it is, or another part of it is a reluctance to use legislative history. Unlike some people who call themselves textualists, Judge Easterbrook doesn't say no, never about legislative history. He's very clear about this, that there are occasions on which you have to resort to legislative history, but it should be a last resort, resorted to very reluctantly. And to the extent you can reach results on the basis of the text, you should do that. So, okay, so does this make you a conservative? Well, you have to figure out what a conservative is. Obviously, you also have to rule out a couple of things. You have to rule out sort of bad faith, that people, of course, someone could, just because they're promoting an ideological agenda, could latch on to a particular methodology. That doesn't condemn the methodology. Also, I should say I want to limit this to statutory issues. I think the question in the constitutional context is different. I think the answer in the constitutional context is there is no connection between a particular view and a particular and a textualist or originalist methodology. But that's also something Frank has said, and I agree is correct, and that's a separate conversation. I really want to talk about statutes. And I think there is a sense in which textualism leads to something that we would ordinarily call conservative. The sense of conservatism is a commitment to a market ordering, an anti-regulatory bias, a bias toward market rather than regulatory orderings. Now, that need not be conservative. There could be instances in which the regulatory ordering would be something favored by people on the left of the spectrum. But in any event, I think when people have the intuitive reaction that textualism and statutory interpretation is conservative, I think that's what they are getting at. And it needs to be qualified, but I think there is something to it. Now, why would that be so? I actually don't have an instance of an Easterbrook opinion that I can use. There are a couple that kind of do it, but they're very complex statutory and regulatory schemes. So let me give a stylized version of the case that came before the Supreme Court a little while ago. This case involved the Endangered Species Act. This isn't exactly the case. As I said, it's a stylized version of it. The case involved the Endangered Species Act, which forbids, among other things, individuals from taking the species. And then the word take is defined by the statute in certain ways, and the definition includes the word harm. One thing a taking is defined as being as a harm. Okay. Now, in sort of this rougher, not quite accurate version of the case, the issue is, okay, does that mean that if you accidentally harm a protected endangered species, you have taken it? You accidentally injure it? Or does taking, defined as harm, mean it has to have some kind of intentionality? Or supposing what you do is not do anything injurious to a particular animal, but impair the species' ability to reproduce itself, say by destroying a habitat it needs. Does that constitute a taking of the species? These are tough questions, and the language alone doesn't jump out at you one way or another that harm necessarily means intentionality. To say, oh, I didn't mean to harm you, someone wouldn't say, well, that's redundant. If you meant it, you have to mean it for it to be harm, right? That's a coherent English sentence. And also in the context of the Endangered Species Act, it is not obviously wrong to say taking a species can include diminishing the chance the species will survive as a species. So here's the question. Is it okay to say, as the Supreme Court, majority of the Supreme Court did over dissent by Justice Scalia in this case in a slightly different context, is it okay to say, well, look, the purpose of the Endangered Species Act is to protect endangered species, and we are going to resolve this ambiguity on that basis, or at least we are going to take into account the purpose of the statute when we resolve this ambiguity. That's going to be one of the things we will think about. Not necessarily dispositive. There has to be a genuine ambiguity. We'll look at other evidence of what these words might mean, but that's one of the things. I think Judge Easterbrook's answer to that question would be no. That's yes, of course, that was a purpose, but there were a zillion other purposes behind the Endangered Species Act, including a purpose of some to see to it that this regulatory regime not get out of hand and not intrude on private people's property rights. That was a purpose too. Why are you privileging this one purpose that was just one of the components of the legislative compromise? I think that's what Judge Easterbrook would say. I'm not sure that's right. I'm not sure it's illegitimate to interpret the statute to say, look, this is the purpose. That is to say, why is it incorrect to say between a market ordering, between letting private owners of property do as they wish with their property, and protecting endangered species, if we have no other basis for making the distinction, the Endangered Species Act tells us protect the endangered species. Now, one possible answer might be, well, it could say that, but it doesn't. It could add a provision, Congress could have added a provision that said interpret ambiguities in a way to protect endangered species. It did not pass such a provision. That's true. It didn't pass the opposite either. It didn't include a provision that said in cases of ambiguities, favor a private ordering. It didn't do either of those things. You might say, well, look, but the background principle in our society is, unless the legislature displaces the private ordering prevails. Background principle, where does that come from? That's not the sort of thing that maybe a textualist ought to be talking about. That come from kind of our general sense of the traditions of the American people. That's not textualist talk. And in any event, even if there is something to that idea that the private ordering persists until it was displaced, why wasn't it displaced? Why doesn't the fact that Congress has entered this area and passed a comprehensive law mean, well, we're changing the background principle? Why isn't that the right way to read the statute? If you were to say, look, this whole talk about background principles, I just don't buy it. We've got the law is what's written down in black and white. I don't go for this background principle stuff. If you were to say that, you would be a textualist, you would be a much more simple-minded textualist than Judge Easterbrook, who has been clear that you can't, words, as he says, don't interpret themselves. You can only interpret words by reference to some kind of context. My favorite example of this, he's not silly enough to say this, but I am, is the words in statutes are not intended ironically, right? There are plenty of literary critics, not very good ones, I guess, who, whenever they're sort of put in a box about something in the text that doesn't correspond to their reading of the text, will say, oh, it was intended ironically. Well, you don't do that with a statute. You don't say, oh, when they said don't harm endangered species, that was a joke. They meant go out and kill as many of them as you possibly can. Background principle, right? And Judge Easterbrook has been very clear in saying, come on, you need that sort of understanding to get to work on a statute. So I guess to the extent this accusation that textualism leads to conservatism has anything to be said for it, that's what it is that there is a bias toward a market ordering. Now, I need to qualify it. This needs to be qualified in a couple of ways. The bias, you could say, wait a second, if there's no federal law in the picture, that doesn't mean market ordering. That means state law prevails. Fair point. I think a totally fair point. And there are some opinions written by textualists that are skeptical of claims of preemption for just that reason. But nonetheless, having said all of that, I think Judge Easterbrook's, uncommonly nuanced and well worked out version of textualism is perhaps subject to this, I don't even want to say criticism, to this cavil.
Thank you, David. Across all three of the panels, Judge Easterbrook's been extremely generous with his time and with his insight and with his candor. So I know we're all looking forward to hearing from him about these 4 terrific presentations. I know we have to clear the room at 1:20, so unfortunately, given that I'd like to get a question or 2 in, we'll give Judge Easterbrook maybe 12 minutes to respond to 40 minutes.
Well, I will try to be very brief, but I'm going to begin by writing something up on the board, which is, you surely have all run into this. B less than PL. It's the hand formula for torts. Douglas Baird has suggested that my opinion in Kmart can be reduced to a formula, which would be the following simple statement.
I really did say this, but
E to the minus R dt power times E t, I'm sorry, I'm out of space here, so we'll go. Bracket V paren by, this time T plus dt, close paren, close bracket, minus C. And all I can say about that is, expect to see this soon in the Federal Reporter 3rd series as an easy, convenient summing up of the holding of Kmart that will get rid of any lawyer's suspicion that this is a 12-part multi-factor test. And you thought you were being challenged by the hand formula. That is, in fact, exactly what the opinion means. I have a brief comment, not in response to Martha's paper, but prompted by it. One of the things she notices is that I've changed my position in a number of cases that have gone on by. Judge Posner changed his position in this case by agreeing to overrule Halperin, which is one of his decisions, and Judge Wood changed her position on constructive eviction and also somewhat changed her position on what the legal standard was. And Martha noticed that that's happened in a number of other cases, and I can telegraph to you that we're about to release probably next week another en banc, which will come out unanimously, in which all 3 members of the panel have given up their prior position. None of the 3 panel members was the Chicago cabal, but all 3 of them have given it up. It has always seemed to me that looking at things a second time is highly beneficial. And one of the changes in Seventh Circuit practice that I made when I became Chief Judge was to stop assigning en banc cases to the judges who were on the panel. One thing that Martha didn't mention today, although you might have inferred it, in the panel in the Mezuzah case, I wrote the majority opinion. Judge Wood wrote the dissent. The en banc opinion, which came out unanimously, was written by Judge Tinder. She mentioned two other cases where votes have been changed, neither of them written by a judge on the panel. The one that you will see next week, not written by a judge on the panel. That's a change in practice designed to promote rethinking of things. I mean, there's another, you may remember that when John Roberts was nominated as Chief Justice, he said he thought it was important to see if he could bring the justices together. Now that's a very difficult thing to do. Oliver Wendell Holmes once referred to the justices of the Supreme Court as 9 scorpions in a bottle. Well, they're not quite that bad, but getting people to rethink is extremely difficult. One thing one can do is change who gets the assignment, which makes things change. Another thing that happens is, again, this is kind of in passing in Martha's presentation, the lawyer for the blocks changed between the panel and the en banc. And one thing that was very much influential en banc about could a reasonable jury infer that the hallway rule was enforced the way it was because of, rather than with indifference to, the bloc's religion, is the fact that on the day of the Shiva, the association allowed a table and a pitcher of water to be set up outside, very large thing in the hallway, and then took down the mezuzah, a very small thing. But of course the mezuzah had religious significance. Now the lawyer representing the plaintiffs had not mentioned that to the panel. If you want to have a favorable outcome saying a jury can find on the best set of facts, one thing you really want to do is mention your best set of facts.
Yes.
One of the questions I asked at oral argument, which Martha didn't mention, is of the plaintiff's lawyer, Gary Feinerman, by the time it got to the en banc court, what's the best set of facts you can mention? And he went right there.
Right.
And I had asked the same question at the panel argument, and the lawyer representing the plaintiffs didn't go there. And indeed, when I asked that question at the panel argument, the lawyer representing the plaintiffs kind of went, well, it was a mezuzah they took down, which of course didn't distinguish between discrimination and failure to accommodate. Indeed, the lawyer at the panel level didn't seem to know there was a difference between discrimination and failure to accommodate religion. Although I won't mention names, I will mention that he was affiliated with a different law school in Chicago. Right? So lawyers matter, the willingness of the judges to reconsider matters, and institutional arrangements matter a lot. And the assignment of our en bancs to the judges who have not written opinions for the panel is an institutional arrangement that I think matters, and in which improvements can be made, were made in the Seventh Circuit. We'll see how long this continues. Now let me say a few words, necessarily a few words, about statutes. My fundamentally textualist approach to statutes is driven in part by my skepticism about the existence of intent, in part, as David emphasized, by my confidence that there's more than one purpose in every statute. It's also results in part by P.T. Barnum's phrase that no one ever lost a nickel underestimating the intelligence of the American public, where I substitute the American judiciary for the American public. And it's not because judges are particularly dumb, but because judges are particularly overworked. There's a strain of academic commentary about judging in the judicial process, which assumes that judges have got all the time in the world to study problem X in great detail and produce a wise solution to it. In fact, the judges of the Seventh Circuit, each judge decides roughly 300 cases a year. There are 2 or 3 issues per case. You can work out how much time per issue the judge has. So what you want is an interpretive method that can be applied by overworked generalists, as opposed to the interpretive method that is best for experts who've got a lot of time to work on a particular issue. And you hope that by choosing the method, usually called textualism these days, one that emphasizes a fairly straightforward reading of the text over imputed purposes and careful balancing and multiple tests and so on. And what you hope by that method is not to get all the cases right, but to depress as much as you can the error rate in having a generalized and overworked appellate judiciary. And one thing I found very comforting about Saul's paper is because he really disagrees seriously with only one of my statutory cases, which suggests, whether that decision he disagrees with is right or wrong, that at least I've held down the error rate as Saul sees it. My internal standard for what it's worth is I strive for an error rate of about 5%, in the sense that I think if somebody gave me these cases again with the same briefs, I'd probably decide about 95% of them the same way. Not clear one can do better, but if you really are trying for a lower error rate than that, if you're doing better than that, you probably find yourself unable to decide the cases. You find yourself in some kind of stasis, and then the litigants aren't really being served. So I think there's more to the textualist method of statutory interpretation than just public choice and just the recognition that multiple member bodies have multiple purposes behind their laws. So that leaves, Leor, 8 minutes.
Well, terrific. I know that the students and friends who've come to join us today will take advantage of that opportunity. So,
and I hope they've written down the formula.
They will. That'll be on the exam. So please raise your hand high and don't be shy. We had the same thing yesterday, and then a few students asked some terrific questions. So let's avoid the 30-second awkward pauses. I know lots of you have questions, and go ahead and ask them.
Remember, this may be the only time in your life you get to ask questions of me, but once you graduate, I'm going to be asking questions of you.
Tom.
I know Professor Strauss just described conservative as not a very adequate description of Judge Easterbrook's philosophy, but I know he's perceived as on that side of the spectrum, and it seems, having gone to 3 of these now, that a lot of the faculty members found very laudatory things to say about somebody who's considered extremely on one end of the ideological spectrum, and I'm wondering why that is. Like, what is it about his jurisprudence or his work that so many people, so many faculty members on different sides of politics were able to find these areas?
Well, speaking narrowly to bankruptcy cases, a lot of these bankruptcy cases are very technical cases of statutory interpretation. It's not the kind of case where it's the Supreme Court talking about some Second Amendment issue or something like that. They're just very technical questions where if I said, what's your liberal interpretation of 548C2 and what's the conservative interpretation, that's just not a very meaningful question. I think the characteristic that he has that not all judges have is he has a real ability to read the law carefully, read statutes carefully, and just show that being a good judge is also being a good craftsperson, and that doesn't have an ideological valence. Also, remember, there are very few dissents in the courts of appeals. It's not as if I don't remember any dissents in any of his bankruptcy opinions. It's not as if people are. There may have been some, but they're not. This at least is not an area of the law that has a strong ideological valence.
But it's also the case there isn't anything ideological about textualism. It can be used as a front for an ideology. Indeed, almost anything can be used as a front for an ideology. But for a textualist, if you've got fundamentally a liberal law, you're going to get some liberal outcomes. And if you've got fundamentally a conservative law, you're going to get some conservative outcomes. And if you think about the Mezuzah case, where the Fair Housing Act would, I think, be described as a reasonably liberal law, the question was, first, how liberal? Did it have an accommodation clause in it? And that's something on which everybody on the court was in agreement from the start that it didn't and doesn't. And second, how do you best understand the facts? And that, in the end, was driven not by anybody's priors or their druthers, but by what the facts actually were and whether they were well explained by the lawyers to the judge to emphasize what you could emphasize. And this is the characteristic, I think, of, it's the difference between good judging and bad judging.
See, what I think is what I said, that it makes a difference to really argue well and try to get things right. And I guess I think that makes a difference in all of our public life, and that, I've said that all undergraduates should study philosophy because they learn to argue with each other and listen and treat each other respectfully and make good distinctions rather than just bleating out something they heard on talk radio. So, you know, if the judiciary doesn't take the lead on that, I don't know who else would.
I have a more aggressive response. You know, I think that, imagine the opposite. Imagine the anti-Easterbrook judge. So here's Easterbrook, and his whole life people have been telling him, I assume, boy, you're really good at reading text, you're really smart, you're really careful, endless curiosity, understands every transaction. It's the most obscure thing in the world, and the opinion begins by explaining the whole radio industry to you, and then, boom, see why there's no standing, or, you know, something. But imagine the opposite person who has succeeded in life by being told, you know, you've got great imagination. You're a sloppy reader, you don't do that well, you don't write well, but boy, you have really great imagination. And there are a lot of judges like that. And I think their job in ways, they see it as a more high volatility thing. You know, I'll create international human rights with my left hand. I'll strike down rights of action with my right hand. You know, I'll just really try to make the world a better place. I think when we celebrate that person after 25 years, you wouldn't get this reaction of, wow, we're so lucky to have this judge. 25 years, the guy's error rate is close to zero. But you would have instead, well, boy, we got wild man here. You know, 18 of those opinions just changed the world as we know it. I don't know where he got the authority from, but boy, I'm happy to live in the world that he fashioned. You know, 56 times, the guy really made the world a worse place, and someone else came along and swept it up afterwards. So, yeah, it's just a different strategy.
Yes, the baseball cap.
Yeah, I was, Judge Easterbrook, I'm wondering if your take on textualism also transfers to your take on judges, meaning that the judge that is appointed is the product of, you know, internal bargaining in the legislature, and why then textualism has any sort of moral authority over some other sort of view.
Well, you have to articulate what the other sort of view would be.
Well, we'll go with wild man.
But I'm you.
I'm glad that
How much time do we have here? Here's the 30-second version. The structure of the Constitution is one that keeps policymakers on short temporal leashes, whether it's 2 years, 4 years, or 6 years, in part because of disgust by the behavior of people like King George, who were appointed for life. How appropriate do you think it is, then, given that constitutional reaction to the behavior of people with life tenure, for the few people who are left with life tenure to claim to be policymakers? The usual understanding of tenure is the reason to have tenure is to protect yesterday's laws and yesterday's Constitution from today's vocal majority. The dark side of tenure is that it can protect the judge's druthers from the actual legislation. It seems to me you want the good side of tenure rather than the dark side.
I hate to have to end things, but we're going to have to, so please join me in thanking